So welcome to this Law for Community Workers webinar, all on bails and AVOs and how can clients comply with them. My name is Yasmin and I'm from the Community Legal Education team at LegalAid New South Wales. And I'm really honoured to be joined by Natasha Wood, who is a criminal law solicitor. I'm calling in today from Darugland, and I want to pay my respect to elders past and present. As we share in knowledge and education today, may we also recognise the learning, the storytelling and the education practices that have been taking place on this land for tens of thousands of years before us. We're really excited to share this topic today. There will be a time for questions at the end, and I'll be monitoring the Q&A. I would also like to acknowledge Bridget Barker from my team, who had done a lot of work in setting this webinar up and was hoping to host it today, but she's unfortunately unwell, and she'll be joining us for other Law for Community Workers webinars in the future. But now I'm going to pass it over to Natasha Wood. Thank you so much, Natasha.
Thank you. Thanks everyone for joining today. So we're going to have a chat about bails and AVOs and how we can help clients comply with them. So firstly, we're going to start off by talking about bails. So the most, important thing that you need to know about bail is it is a court order. I have jumped ahead, sorry, going back. What we're going to cover today. So we're going to deal with what is bail, bail conditions, consequences of breaching bail, how to vary your bail, and then we're going to have a chat about AVOs. So what is an apprehended violence order? What kind of conditions can be imposed? How you vary an AVO? And where to get further help or assistance in relation to bails and AVOs. Okay, so what is bail? So bail can be imposed in two ways. So the police can put a client on bail, or the court can put someone on bail. But basically, it is a set of conditions that are imposed either by the police or the court to address what they call a bail concern. So bail concerns are set out in Section 17 of the Bail Act 2013. Easiest way to find that piece of legislation, if you're looking for it, is to jump on Google, type in Bail Act 2013 New South Wales, and you'll get two links. The first one is to the New South Wales legislation website, and the second is to a site called Ostley. Both of those will show you all the separate conditions. But basically, in terms of bail concerns, what they're actually looking at is there a risk that your client is going to fail to appear at court? Are they a risk of committing a serious offence? Are they going to endanger the safety of any victim in the matter? So in that, they're generally talking about domestic violence offences, but they are also concerned about risk to other individuals or the community. So that's public order offences. So if there's, weapons or violence offences occurring in the street, that type of thing. Then the last thing they're looking at is there going to be any interference with witnesses or evidence? So again, there we're generally talking about that DV context. So is an alleged domestic violence offender going to try and approach the victim or any other witnesses to try and get them to change their story? So if we can just move on, thank you. Bail conditions. So there are a number of different conditions that the police or court can impose to address those bail concerns. So I'm not going to bore you all by reading out each of the sections of the Bail Act. You can go and look at that if you choose to. But basically, they fall into certain categories. So in terms of conduct conditions, we're talking about a condition that would say not to do certain things or to do certain things. So, for example, engaging in treatment or not to attend a certain place. In terms of security conditions, that can be either something that the client puts up themselves, and that can be what they call a self-surety with security, which means that they have to provide a sum of money to the court before they're released on bail, or it can be without security, which works kind of more like a fine. So if they breach their bail, then they're obliged to pay that amount. It can also be another person who puts that up on their behalf, usually friends, family members, employers. In terms of character conditions, sometimes the court will ask someone in the community to sign what they call a character acknowledgement, which is an agreement or basically a document they've got to go into the court registry and sign that says, I'm associated with this person and I state that they're a person of good character. We can also see those conditions as a pre-release condition if someone is required to sign that person out. So if your client's in custody in the cells coming before the court for the first time on a bail application, the court might say they can live at this address, but I want the occupier of that address to come to court and sign an acknowledgement saying that I'm associated with them, I'm the occupier of that premises, and I'm happy for them to reside there. Then we have accompaniment conditions. So that's things like a condition that would say that they're not allowed to leave home unless in the company of someone else. So like a curfew type condition. And then the last sort of category is enforcement conditions. So that is if the court imposes a abstinence condition, so says that your client can't drink alcohol, they can be randomly tested by the police when they're reporting. If the court imposes a curfew condition, the police have the power to then come to the house and check that they are actually there during those hours. The most important thing to be aware of in terms of enforcement conditions, and the court almost always makes it, but we need to check that there are restrictions on those orders so that they can't be abused. And by restrictions, I mean the court will usually say that they can be drug tested, but not more than once a day, or there can be a curfew enforcement check, but not more than once in a 24-hour period. The most common type of bail conditions that you will see your clients placed on are a residence condition, which is obviously that they live at a particular address, and then reporting conditions, so that they've got to go to a police station and essentially check in. They turn up at the counter, they say, my name's Joe Bloggs, they get signed off, and then they go. We often see, particularly in domestic violence offences, no contact conditions. So not to contact usually the victim or any prosecution witnesses. Now, no contact conditions will sometimes have further conditions attached to them. So they might say not to contact unless through a lawyer or unless agreed in writing between the parties. But if you have an outright no contact condition on your bail, or your client has a no contact condition on their bail, that means no contact whatsoever. And the most important thing that we all need to be aware of is that applies regardless of anything that anyone else involved in the matter does. So if we're talking about a domestic violence context and you have a client who has a condition that says do not contact the complainant in this matter, and the complainant sends them a text message and they respond, they've breached that order. So no contact means no contact through any means whatsoever, even if instigated by another party to the proceedings, unless the condition specifies otherwise. Place restrictions will generally have further details in them. So they'll say, for example, in this area where I'm in the Northern Rivers region, the magistrate in Byron Bay will often impose a restriction on entering the Byron Bay CBD. But if it doesn't say something like that, Byron Bay CBD, it'll say not to go within 10 kilometres of a certain address, or it will have to have some kind of distance on it or identifying information to allow your client to understand where they can and actually can't go. Curfew conditions we kind of talked about a little bit, but generally, example of a curfew condition is not to leave home between 8 p.m. and 8 a.m., meaning 8 p.m. at night, you've got to be home. You can't leave until 8 a.m. the next morning. There are additional conditions that they can put on that. So it can be curfew not to leave home between those hours unless with mum or a support worker. But the most important thing with a curfew condition is that you understand whether or not there are any additional parts to that, or if it is a blanket outright, you cannot leave home. In terms of abstinence, we see that in relation to drugs and alcohol. So it's important to check the condition, whether it says abstinence from alcohol or whether it says abstinence from drugs or both, because sometimes it's not just one or the other. Sometimes it is both. Okay, so I'm just going to try and deal with questions that have come up that relate to each of the slides as they come. So the question of who should a service contact if they run programs that help the client that's run outside of the client's bail conditions? So we'll talk about that in a bit more detail when we get to variation, because if the bail conditions don't allow the client to participate in certain things, we would need to file a variation to allow them to participate in those programs. It's not something that they can just go and participate in. They will be in breach of their bail. So we would have to file a variation. And we'll talk about that a bit more under the variation slide. But just let me know, Glenn, if that doesn't get answered when we're talking about variations. In terms of a question of what is the difference between the police and court-ordered bail, absolutely nothing in terms of the conditions and the obligation to comply on them. It is the only difference is when your client first gets arrested and they've been charged, the police that arrest them, called the officer in charge, gives all of the information to the sergeant who's on duty, and that sergeant will make a decision if that is something that can be dealt with by way of a police bail. So there we're talking about people who have nothing on their criminal history. If they say that there's none of those bail concerns in place, so first-time offenders, low-risk offenders, they'll give them police bail. So instead of bringing them before the court, they release them on bail. And then the more serious matters come before the court for a magistrate to decide whether or not bail will be granted. But otherwise, there's no difference between police and court bail. Bail is bail, and the obligation to comply with the conditions is the same. And then we've got a question, what evidence needs to be provided to make sure that bail conditions are legit? So I guess there's a section of the Bail Act, Section 20, that says that all bail conditions must be imposed to address a bail concern. They must be reasonably capable of being complied with, and they can't be more onerous than is required to address the bail concerns. So, for example, if you have a client who is homeless, they are not going to have a residence condition. Even though they may not have a record that suggests that they have not complied with things in the past, they can still impose a reporting condition because the police will want to have some means to maintain contact with that person. So if they had a residence condition, they'd be able to go there and find them. Without that residence condition, they would want them coming into the police station. That's when you're going to see the once, maybe twice a week type reporting conditions. It isn't something in that example that we would say there was any necessary fail to appear risk, which is what a reporting condition would generally be imposed to deal with. But in the absence of that residence condition, they can impose reporting. The difficulty comes about when we're talking about, oftentimes when clients are in custody, they will agree to any condition that will ultimately see them released from jail into the community. But then what happens is they can't actually comply with those conditions when they're released. So that section of the Bail Act that says that the condition must be reasonably capable of being complied with, whilst that's correct, it is obviously an obligation on the client and also on the legal practitioner that is representing them on that bail to ensure that they are in a position that they're going to comply with the conditions that they're offering, because the court can say that bail was only granted because of the strength of those conditions. So if we try and vary them later, the court can say no, because in the absence of that condition, I wouldn't have granted bail in the first place. So it's really important that we all try and work together at that early stage of the first application to make sure the client isn't released on bail conditions that they can't comply with. Then we have a question that says, can clients cancel an AVO or change the conditions to allow the partner to visit the kids? So I'm going to just pause that one for a moment because we do have some slides in relation to that. And if you can just let me know, Jane, after we've dealt with that, if we haven't answered your question. So at this point, I think we'll move on to the next slide. Okay, so consequences of breach of bail. So the main thing is what we call a detention application. And so that is proceedings that the police bring to get the matter back before the court. So say, for example, your client was on bail with a condition to reside at an address in Lismore, and there was a curfew condition, and the police went there to do an enforcement check on that, and your client wasn't there, they would bring what they call a detention application, which is basically relisting the matter before the court. And then it's a matter for a magistrate to determine, firstly, was there a breach of bail? So your client will be asked, do they admit the breach or not? If they do, then obviously the breach is established and we move on to the decision. If the client doesn't admit the breach, the magistrate will have to make a decision based on the material before the court, which is usually the police version of what they say happened. So in the example I gave, Officer Jones says, I went to the address on this date and this time. I knocked on the door. No one answered. I went back an hour later and someone answered and said, no, he's not here and he hasn't been here for days. Then your client can introduce evidence at court if there is something to support the breach. So say, for example, if there was a condition, an additional part of the condition that said that they can't be at that, they can't leave that address unless in the company of their mum, they might want to bring mum along and say, he was with me. Then the court will determine all of those things, will take that into account and determine if there was a breach of bail. If they say there was no breach of bail, then the bail that they were originally on just continues and the matter remains listed as it previously was. If they say that there was a breach of bail, then they usually go through the process of redetermining bail. So they've got to make a decision to either grant bail either on the same or additional conditions, or alternatively to refuse bail, in which case that means that they will be held in custody until their matter is ultimately finalised, either by way of a sentence or a hearing. So it's really, really important that regardless of what the conditions are, they comply, because if they don't, they risk being arrested and sent back into custody. If we could have the next slide. Okay, so talking about variations now. So when bail is imposed, regardless of whether it's police bail or court bail, the only way to vary it is by an application to the court. There are a few different ways that you can do it, or by a few, there's two. So you can make an application to vary by an authorised justice, which is a registrar of the local court. And if we just jump to the next slide, you will see, sorry, the next one. This is the form that you would need to fill out if you're seeking an application for a registrar to review bail. So they have the power to change residence conditions, to change reporting conditions, to change association conditions and curfew conditions. And you'll see there's different sections on that form that relate to all of that. So what you would need to do if you're seeking that variation, obviously if your client has a lawyer, the lawyer would be completing this application, but all of the client's details and the details of the offences and the court appearance go in at the top, and then you just indicate on the form exactly what you're seeking. So for example, if it is your client was bailed to an address in Lismore and they've now got a permanent, they were in temporary accommodation and they've now got permanent accommodation in Ballina, then we would file one of these forms asking the registrar to vary the bail. The reason we do it that way is what happens is that gets sent to the police for their comment. They usually, if we can support it, consent to the variation, and the registrar does it in chambers. So the client doesn't have to come to the court. They don't have to appear in front of a magistrate. It just gets changed and it can all occur quite quickly. So that's the easiest way to change either a residence or a reporting condition. So you can change things like the station in which you're reporting to. You can change the number of days that you're reporting. You can change, as I said, addresses in terms of association conditions. That might be either a co-accused or a prosecution witness or complainant in the matter that you're seeking to ask them to allow you to have contact with. And then in terms of the curfew condition, you can be asking that in terms of a variation, that it be reduced. So you can change the hours. So if they said things like in your original conditions that you can't leave home between the hours of 8 and 8, and your client got a job where they'd be working until 10 at night, then we'd file one of these variations seeking to change those hours. So that form just gets filled out, sent to the court, and then the court will write back and indicate whether or not they're able to deal with the application. So if we can go back 2 slides. Okay, the second is an application for the court to vary bail, and that means a magistrate. So if we just jump to the next slide, this is the form that we would need for a magistrate to vary bail, and you'll see that it's relatively the same kind of information that's required, your client's personal details, the court details. You tick the box of which condition you're trying to vary. Then you've got to put in the details of the proposed changes of the condition. So there, we'll just use residence because it's the first. You would say, I am bailed to reside at this address. I want to change my address to this new address. And then over the page in the grounds of the application, you would say why. So they just want an explanation of, I was in temporary accommodation, I've now got permanent accommodation. And then sign it, date it, and that gets submitted to the court. And the court will give that a listing. So a date where your client has to attend the court and go before the magistrate to convince the magistrate that the variation should be granted. So the reason you would require this form as opposed to the other form is if the police don't agree, or if it's a decision that the registrar says that they can't make, it'll get referred to the magistrate and you'll need this form. All of these forms are found on the New South Wales Courts website. So when you go on to New South Wales Courts, there is across the top, I think it's the third one in, says forms. Then there's a list of where you can click on bail, and then all of the forms will generate there. But if you have any dramas in accessing forms or anything like that, Legal Aid can certainly send them to you, or assist if you can't get access to things. If the client's legally represented, the lawyer will be doing all of this in any event. Then if we can just go back to the slide previous. Okay, so if you are doing this second form, application for a court to vary, that will require supporting documentation because the magistrate is more strict than the registrar in terms of their decisions. So if a registrar has an application in front of them seeking to make a variation that they are permitted to grant, and the police have agreed to it, they will automatically grant it. Magistrates, not the same. Magistrate has to be convinced that they should grant the variation and that any variation doesn't impact any of those bail concerns or put anyone at any increased risk. So they will require supporting documentation. So if we're seeking to vary a residence condition, they will want evidence that your client can live at the address that they're proposing to reside at. So that's usually in the form of, if it's going to be their premises, they'll want a rental agreement. If they're saying, I'm going to live with my friend, they will want written consent from the occupier of the premises. So it can even be an email. It doesn't have to necessarily be, a stat dec or affidavit. It can be an email, but it needs to say that their full name, their date of birth, that they are the occupier of the premises, and that they consent to the client being bailed to reside at that address. Now, that, of course, doesn't make that person responsible for the client in any way, but it's just them saying, I'm happy for them to be bailed there, because without that, a lot of magistrates will not vary those types of conditions. Okay. So if we're moving on. All right, so I'm just going to have a quick look at the questions again to see if there's any questions in relation to bail before we move on to AVOs. Okay, so question of how do we help a client who is in custody for breach of a bail condition? So generally, when a client is in custody, so they've been arrested for breach of bail, they will be represented by the legal aid duty solicitor. So it's probably best to get in contact with that person. So they will be physically at the courthouse representing your client. If you are unable to attend the court to support them in person, then we'd recommend that you contact the nearest legal aid office, because they'll then be able to get in contact with the solicitor who'll be able to reach out to you. If your client is in police custody, they will allow you to attend the police station and support them. But if they are in a court where they are transferred from police custody to correctives custody, so that's the process in Lismore, anyone who's arrested originally comes in through the police, they get processed and then transferred to correctives. Once they're in correctives custody, they won't allow support people to visit with them. So that's why it's so important to deal with the solicitor. All right, so I'm going to move on to, sorry, there's another question. Is there a way he can come out of custody before the final hearing? Okay, so is that in terms of that question, are we talking about clients being in custody, there's been a breach, so they've been in custody, they've got bail, there's then been a breach of bail and they've gone back into custody, and we're wanting to know how we get them out again before the final hearing? If that's the case, you can make, so even if a detention application's been brought by the police, and that's granted, so the magistrate revokes their bail and holds them in custody. If there's a change in circumstances, we can file what they call a Section 74 bail application. So that's asking the magistrate to reconsider bail based on the fact that there's been a change of circumstances. So it might be that they'd breached their residence condition because they could no longer reside there. At the time the detention application was brought, there wasn't any alternative accommodation, but you've now got them somewhere to stay. So you'd be asking the magistrate to redetermine that application. Sometimes another change that we often rely on is treatment or rehabilitation. So if a client wasn't engaged, but there's now services that they can engage with, or if they've been accepted into a residential rehabilitation facility, then we can file a further release application in the local court. There is also obviously Supreme Court bail applications that can be made, but that is something that would need to be canvassed with the solicitor that was dealing with the matter, because there are some different tests in relation to those matters. All right, so if we move on to AVOs, and then we can deal with some more questions about bails at the end if there is any additional questions. So AVOs. So there's two different things you're going to hear when you're talking about AVOs. You're potentially going to hear people refer to APVOs and ADVOs. So APVOs stands for Apprehended Personal Violence Orders. Best example of that would be neighbours. So not in any kind of domestic relationship, but they're having a dispute about something, it becomes physical, and one neighbour wants to bring an order against the other neighbour, stopping them from doing certain things. ADVOs are Apprehended Domestic Violence Orders. So made where there is a domestic relationship between the parties. Most commonly we see it between partners, but it also includes parents, children, anyone who you're residing with, and it also includes people who are in a relationship with those people. So for example, it would include if you were in a relationship with someone that was classified as a domestic relationship, that relationship ends and you have an altercation with that person's new partner, that's going to include that domestic relationship. So AVOs are conduct orders. So basically what that means is it's a court order that protects one person from another person who has caused them to fear for their safety. So there are 3 different types of AVOs. An AVO will start as what they call a provisional order, which is an urgent application that's made by the police. So when a complaint's made to the police, if they think that an order needs to be put in place for someone's protection, they will make that order, and that is called a provisional AVO. When the matter first comes before the court, the magistrate will make that order what they call an interim order. So that hangs around from the very first court mentioned date until the matter is finalised. It is usually in the same conditions as the provisional order. And then we have final orders. So that's when the matter has been dealt with. The magistrate imposes an order that will stay in place for a particular duration. So usually 12 months, 2 years, depending on the seriousness of the matter. And they will set the conditions of those orders. In terms of varying an AVO, you cannot vary a provisional order. So when the police put an AVO in place, between the day that that's imposed and served on your client to the first day the matter comes before the court, we can't vary that order. We can only vary interim and final AVOs. So it's really important, if your client is served with an AVO and there's going to be an application to try and change the conditions, they need to speak to their lawyer as soon as possible so that the lawyer can understand that at that first mentioned date, the court needs to be advised that there's going to be an application to vary the conditions, because we can only vary it once it becomes an interim order or a final order. All right, can we move to the next slide? Okay, so for AVOs, the test is set out in the Crimes, Domestic and Personal Violence Act 2007. So for domestic orders, it's in section 16, and for personal orders, it's in section 19. Basically, it says the same things, and that is that the court must be satisfied, or if the court is satisfied, on the balance of probabilities, which means more likely than not that a person has reasonable grounds to fear and in fact fears the commission of an offence and or the engagement of the other person in conduct which intimidates or stalks the person. And the court thinks that that conduct is sufficient to warrant making the order, then they will make an AVO. They will then turn their mind to what conditions need to be on that order to protect the person. So that is basically a lot of words to really say, if the court thinks that it is likely that the person has fears, there's a reasonable ground to fear because of something done or said by your client, then they will impose an order. So if we move to the next slide, we're going to have a look at some of the conditions that can be imposed. But just before we get to that point, something that you all need to be aware of is section 39 of the Crimes, Domestic Personal Violence Act. A lot of people aren't aware of it, and what it says is if your client has a charge, upon pleading guilty or being found guilty of a domestic violence offence, the court must make a final AVO for the protection of the victim or the person against whom the offence was committed, unless they're convinced that there are reasons that they don't need to do that. Generally, the only time we will see a magistrate say, I don't need to do it, is when there's already an AVO in place. So, for example, if your client is charged with common assault, damaged property are usually the most common DV offences we'll see come before the local court. If they plead guilty to that, the magistrate will make an associated AVO that says that they can't do certain things. If they plead not guilty to the charge and it goes to a defended hearing and they are then found guilty, the magistrate also will make an associated AVO. So if we can jump forward to the next slide, this one has a lot of information on it, but basically it's just a printout of all of the different types of conditions that they can have on an AVO. You will hear people refer to condition 1 as what they call a standard condition. The reason they say that is because you'll see from the slide, it says not to assault, threaten, stalk, harass, or intimidate, and not to destroy or damage any property that belongs to or is in the possession of the protected person. The reason we say that that's a standard condition is I can't do any of those things to any of you. If I did, I would be charged with a criminal offence. The difference that condition makes is if there's an AVO in place that has that condition 1 on it, and I was to do any of those things, so say I was to assault you, I punched you in the face, what that means is I would be charged with contravene AVO and assault. And the legislation says if you breach an AVO with an act of violence, the starting point for sentencing is imprisonment and the court will work backwards. So usually they start at the bottom in terms of penalties and work their way up. But if you breach an AVO with an act of violence, they will say, is imprisonment warranted as the first question? So even though they say standard condition and it doesn't necessarily have any additional implications on your client because they can't do any of those things at law anyway, what it means is the consequences for them if they were to do any of those things are significantly harsher. Condition 2 is that condition that we were talking about before when we were talking about bails, which is not to have any contact. And it reads, must not approach or contact in any way unless that contact is through a lawyer. Now, if your client has that condition, it doesn't mean that they have to run scared. It doesn't mean they've got to sit at home, never go anywhere, never do anything. If they were at Woolworths and they were walking down the aisle of the supermarket with their trolley full of groceries and the protected person's coming towards them, they don't have to dump their groceries and run. They just go about their business as usual. Obviously, simple things like don't gesture at them, don't stick your finger up, don't poke your tongue out, don't speak to them, don't have any engagement or interaction with them at all. Keep walking and there's no breach of that. Obviously, if they started following them around the supermarket, if they made any gestures or spoke to them, then obviously that's going to be a breach of that condition. But simply being in the same place at the same time in a small town isn't going to place them in breach of that condition too, provided they don't do anything that would meet the definition of contact or approach. Approach, obviously, in this context, meaning going up to them and actually making a physical attempt to engage with them. Contact being any form of contact. So physically in person, text messages, social media posts, even contact through other people. So you can't ask someone to pass on a message for you. So if your client, say his name's Jack, so Jack's on bail, and Jack's got a condition that says not to contact his partner Susie, Jack can't say to his mum, go tell Susie I said XYZ. That's going to be a breach of that condition. The only way that they can pass messages is through a lawyer, and obviously a lawyer isn't going to pass messages. They may communicate in relation to children or matters of necessity, access to property, stuff like that, but they're not going to just pass on, he wants to say XYZ. In terms of condition 3, it's not one of the more common conditions that we see, but it occurs usually when there's a child named on the AVO, and it says not to approach the school or any place where the person goes for study, any place that they might go for childcare, or they can specifically list any particular place. So usually they're in condition 3C. They might list, say, for example, the address of a school or other kind of education facility. Condition 4 is not to approach or be in the company of the protected person for 12 hours after drinking alcohol or taking illicit drugs. So in terms of that condition, you can have contact. You could live with the protected person. You can do everything that you would previously have been able to do. You just can't have contact. And that means, again, physical, in-person, text messages, social media, any contact, any reference whatsoever within 12 hours of drinking alcohol or taking illicit drugs. The most common thing that we see with that condition is people who go out to dinner or to the pub with their partner, and there's a condition 4 on the AVO. They consume alcohol together and they say, well, I thought that was fine because we were together. You can't get around the conditions of an AVO because the protected person said it was okay. If the condition is in place, it is enforceable, and if you breach it, the police can charge you with breaching the AVO. So regardless of anything that any protected person says or does, the obligation to comply strictly with these conditions is on the client. The other thing that we see trip people out all the time is they think that because the protected person did something, it's okay if they do. So, example, condition 2, there's no contact order in place, and the protected person sends your client a text message. Your client thinks it's okay to respond. That is not the case. They are in breach of that condition if they respond. Obviously, as far as the court's concerned, it's subjectively far less serious than if they were contacting the protected person and making threats, but it is nevertheless a breach, and they can be charged and they can receive a penalty for that. Same deal with condition 4. If they were, going out to dinner and the protected person said, I'm going to have a drink, it's okay if you do as well. Not the case. It's going to be a breach. You cannot have contact within 12 hours if you have that condition 4 in place. Condition 5 is not to try and find the protected person. It is usually a condition that you would only see in very, very serious domestic violence type offending, but basically it means what it says. You can't make any attempt to try and find out where the person is living, working, spending their time. And if you do, you can then obviously be charged with breaching the AVO. So if we move on to the next slide, the conditions keep going. So condition 6 is a very common condition that you'll see on AVOs if your client has an AVO with someone that they have children with. And it is an alternative to condition 2. If you have a client who has children with the protected person, or if there are children named on an AVO, it's really important that you speak to the lawyer about making sure the AVO is condition 6, not condition 2, because condition 2 allows no contact whatsoever, and condition 6 is the condition that we use so that they can have contact with children. Now, that can occur through a lawyer. It can be to attend counselling or mediation. It can be as ordered by, when it says this, it means the local court or another court, so family court jurisdiction, as to contact with the children, as agreed in writing between the parents for contact with the children, or as agreed in writing between persons with parental responsibility for the children. So the most common one we see is D and E, but the way people get into trouble is they think that they can just write down, we're going to live together. That's not what this condition is designed to achieve. It will allow some contact, but it is designed to allow contact solely for the purposes of facilitating contact with the children. So, for example, if your client had a written agreement that said, I can contact my ex-partner on this phone number between the hours of 6 and 8 every Monday, Wednesday, and Friday. Sorry, my light just turned off. To have contact with the children. But when they made that phone call, they then went on a rant to their ex-partner about a whole bunch of issues unrelated to the children. That's going to be a breach of that order. So it's very strictly enforced that it be a specific agreement as to contact with the children. So it's usually like that example that I gave in terms of phone contact's going to be on these days between these hours on this number, and both parties sign that. Or other things we see are mum's going to drop the children at the park at this time and dad's going to come and pick them up. And it's designed, as I said, solely for contact with the children. It doesn't allow the parties to live together to basically circumvent the AVO. It is only to facilitate contact with the children. Condition 7 is not to live. Usually we see 7A, which is at the same address as the protected person, but they can also have 7B, which is when they say you can't live at a particular address. So that's, again, usually in a domestic violence context. If there's been something that's occurred at the home, they'll impose a you can't live together condition. Then we have conditions 8 and 9, which are very similar, but you will see the main difference between them is that condition 8 says that you can't go to any place where the protected person lives or works or a nominated place. The wording of condition 9 in terms of A, B, and C is exactly the same, but the difference between the conditions is that order 8 is just that you can't go into those places. Order 9 imposes a meterage restriction on any of those places. So that's another thing that causes a lot of problems for clients, because we'll see AVOs that say not to go within 100 meters of a certain place. That can usually be somewhere that might be a main street in a town, or even if it's a residential address. Things we need to think about are how close is that to the main highway? If the client's driving down the highway, are they in breach of that order? So we like to avoid condition 9 where we can, because obviously our clients don't walk around with tape measures. How far is 100 meters? Are they in breach of it? Are they not? But it's really important that if your client does have a condition 9 on it, that those are the sorts of things that we're turning our mind to help them comply with it, is how far is the meterage restriction, and where are the places that they're not allowed to go, and what does that mean for them in terms of their general getting about, their going about their business, attending work, all of those types of things. And then we have condition 10, which is to, sorry, my computer's just frozen. So condition 10 is not in relation to firearms. So you can't possess firearms or prohibited weapons if you have a condition 10 on your AVO. That will mean that if you were in possession of any firearms, that those firearms will be seized by the police, and that you obviously can't make any application to have any additional firearms in your possession. The prohibited weapon part of that is a little bit strange, because obviously clients can't have prohibited weapons in any event. If they do, they're going to be charged, but it's in the condition in any event. So that is a summary, I guess, of the conditions. And then moving on, we're going to talk about variation in a second. But before we do that, we're going to talk about obligations to comply. So I have briefly touched on this, but just to really, really reinforce a couple of things. The first thing is that there is absolutely no obligation on what we call the PINOP, which is the person in need of protection. So the person whom the AVO has been brought out to protect, they don't have to comply with the conditions. So if there is a condition 2 on the AVO, your client has to comply with that, but the protected person doesn't. And it's something to be mindful of, because it often sees our clients in breach when they then respond. You can have a situation where there are what they call cross AVOs. So both parties have an AVO against each other, but it is not common. Most of the time, only one party will have the AVO, and it's only the party with the AVO against them that has to comply with it. And then the second thing is, again, I've already said about it, but I'm just going to reinforce it. You've got to comply with the conditions regardless of the PINOP's wishes or invitations. So if there was a condition that said, condition 8, not to come to the house, and the PINOP said, come over, if you do that, you're in breach. And we've, again, touched on it, but the consequences of breach are criminal charges. So, variation of AVOs. The only way to vary an AVO is by making an application to the court. So there is a form that you fill out. So if we move on to the next slide, this is the form. And this form, very unhelpfully, cannot be obtained online. You need to go to a local court registry, and so the office at the courthouse, and obtain a copy of this form, or legal aid can provide the form. Your lawyer should, or client's lawyer should, be submitting these applications on their behalf. But if you ever do need it, it's a form you've got to get from the court registry. Then what happens is this form gets filled out, sent to the court. It'll get a listing date before a magistrate, and the magistrate will consider whether or not they're going to vary the conditions. And they're looking at what the conditions are. Are they particularly onerous on your client? So, preventing them from accessing their own home, making them homeless, all that kind of stuff. and then is there any alternative conditions that could be imposed that are less restrictive, but that would still provide adequate protection to the protected person. The most important thing to understand with AVO matters when the application is brought by the police is that anyone who's a party to the proceedings can bring an AVO variation application. So the police can, the protected person can, and the defendant or your client can. But what that means is that all three of those people get a say in the application. So just because your client and the protected person agree and want the variation, the police can still oppose it. So if it's the police's application for the order in the first place, they will get to say to the court, we agree or we disagree. If it is a domestic violence offence that is before the court and an associated AVO, and your client is seeking to remove things like no contact and the matters listed for hearing, it's highly unlikely that the court will grant that variation because they will say no contact until the court matter has been finalised. So can we go to the next? Okay, so where to get help? So in terms of AVOs, if there is an associated charge, we would ask that you contact, I've got on that slide there Lismore Legal Aid, but obviously we're statewide. So whatever legal aid office is closest to your location, if there's associated charges, generally legal aid will be able to assist and represent your client. Obviously, there's different eligibility tests, but it is a good idea to at least reach out at an early stage so we can refer you in the right directions. LawAccess, and we've provided the phone number there to give you or your clients advice in relation to AVO matters as well. There is also a free mobile app for anyone in New South Wales who has an apprehended domestic violence order. So if your client is tech savvy and does have access to things, that may be a good referral for them. And also just, I haven't put it on the slide, but in terms of bails, if your client identifies as Aboriginal or Torres Strait Islander, also consider referring them to the ACLOs who operate at court as well, because they have programs that can assist clients in relation to compliance with AVOs and also compliance with their bail conditions. So it's a really good service available to clients who identify. So that is what I wanted to talk to you about so far. So looks like we're up to questions if people have questions.
Thanks so much, Natasha. I'll let you filter some of those questions that have come through, but I did answer one just about the presentation slides. So as well as the recording of this webinar, you will receive the presentation slides as a handout, and that will be sent in the next couple of days.
Thank you. Okay, so Glenn, I'm just going to go back to your question. So who should a service contact if they run programs that help the client that's outside of the client's bail conditions? Are you happy with the answer that we gave in relation to that question? So say, for example, if your client has a condition that says not to leave home between certain hours or not to attend a certain location, what we would do is ask the support program to provide us with a letter of engagement, so saying they're going to attend on this day at this time, and then we would file a variation application with the court to allow the client to attend that program. Okay, so question of who can vary bail, police bail? Does it have to go before the court, or can the police vary it? So once bail's in place, only a court can vary it. So the police do have the ability to impose conditions initially, but they can't then vary the conditions. Only a court can vary bail conditions. Same with an AVO. So the police can impose the conditions initially in the provisional order, but they don't have then any authority to vary it. It's got to go before a court. Then we have a question of, can clients cancel an AVO or change the conditions to allow a partner to visit the kids? So answer to, can you cancel an AVO? It's called an application to revoke. Yes, you can file one if you have ongoing court proceedings. It is highly unlikely that a magistrate will revoke an AVO outright. They may be willing to change the conditions, make them less strict, put in some additional conditions that may be more appropriate to work with the situation. Like we're talking about, if there was a condition 2, changing that to a condition 6 to allow contact. But it's highly unlikely that when there are ongoing or pending court proceedings that the magistrate would revoke an AVO. It would be more common if it was a standalone AVO application with no associated charges. But it's that same form that we had on the slides, because it's an application to vary/revoke. So if you were ever needing to do it, it's that same form. Okay, another question is, what happens if you occasionally meet the protected person? So I'm assuming in terms of that question that we're meaning that there was a no contact condition in place and you've got a client who is having contact. Obviously, the strict answer to that is you've got to comply with the conditions, because there's consequences if you don't. Obviously, the police have to be aware that a breach has occurred to take action against it. So either they've got to see it themselves, or the protected person has to make the complaint. So unless the police are aware, there's not going to be any action against the client. But obviously, the legal advice is if there's a no contact condition in place, then you need to comply with that condition, because if you don't, you are potentially at risk of being arrested, charged with an offence, and then being bail refused by the court. Question of, people living in the same house can have AVOs on each other. What sort of AVOs can they have? So they could have, so it'd be a domestic, they're living together, so it's an ADVO. And usually if they're living in the same house, the conditions that we would see are 1, which is your standard condition, not to assault, threaten, stalk, harass, or intimidate, and not to destroy or damage any property. And condition 4, which is you're not to have contact within 12 hours of drinking alcohol or taking illicit drugs. Obviously, you couldn't be living together and have a condition 2, because that's no contact. You couldn't live together and have a condition 7, because condition 7 is not to live together. But absolutely, you could have conditions 1 and 4, which basically means relationship goes on as per usual, provided you don't breach by doing any of those things. Okay, so there was a question about bails that says, noting the less strict option with the justice to vary, would it not be best to use this option? So yes, we will always try and use, if we're varying bail, we'll always try and use the option to vary through an authorised justice or a registrar, as opposed to bringing the matter before court. But sometimes we come into situations where we can't do that. That would be if the police won't agree. So if they don't consent, then it has to go before a magistrate. Or if it's a condition that the registrar says that they don't have the authority to review. So That's things like a surety condition, stuff like that. They don't have any power over those conditions. And so abstinence conditions, things like that, a registrar cannot deal with. But if it is something like a residence or reporting condition, it's 100% quicker and easier if we can get the police to agree to just file it through the registry, because it happens straight away. Usually within, an hour or so of sending it through, they've sent it back to us saying, yes, it's done. Whereas if you send it to the court, you can wait at least 3 days to get a listing before a magistrate. Then we have a question. What if a pin-op comes to the place of a client where the client had an AVO not to go near the pin-op or the pin-op's place? So if you have a client, so you don't live with a protected person, so you live in separate premises, but the protected person turns up at your address, obviously, if you haven't invited them there, then that's not going to put you in breach of any of your conditions. If you then have a no contact condition and you invite them in to the premises, then obviously that is an issue. And recommendation would be, if they turn up uninvited and there is conditions of the AVO that are going to put your client at risk of breach, that you contact the police and you advise them that they've attended the premises uninvited, and that is basically a matter then for the police. It protects your client, obviously, in the sense that they're unlikely to take action when they're the ones that are reporting this person's turned up at my house. It becomes more complicated, obviously, when the client then engages with the protected person, lets them in, then the protected person goes and makes a complaint to police. So it's always the advice of, regardless of the situation, comply with the AVO. If protected person turns up and there's no contact, don't engage with them, and contact either lawyer if you have one or police if you don't. And we also ask clients just to keep a record too, if there is ever any interaction or anything, just keep a record of the dates and times of that, because we may potentially need it in the long run. In terms of a question we've received about the app, it's more just information. So in terms of if they've got questions, there's a whole bunch of different links and things that they can click on, and just information services that are available to them. But obviously it's not legal advice. If they're needing legal advice, Legal Aid, LawAccess is definitely where to send them. And then question, can we obtain an AVO on behalf of elder clients or clients with a disability who struggle to access police stations or courthouses? So you can fill out the application with them and take it to the court and file it. You can't make an application on someone else's behalf. So what that means is, obviously it has to list your client as the person in need of protection. It can't be in your name for their protection. So obviously if you're doing it in consultation with them, no issue whatsoever. If it's a solely an access thing, they can't get there, then yes, you can. But the court will require them, when it gets listed before the court, to attend by some means. So either physically in person or via AVL, if it's a court that has those facilities. So like on the TV screen, sort of similar to what we're doing today. But no issue whatsoever with, particularly if you've got clients, who can't read and write, there's no issue in terms of, completing the documents and everything for them, but it does all need to be in consultation with them, and obviously they're the person who's named on it. Okay, so then question, I met a lady whose husband 3 times hit her and broke her nose. How come he was not put in prison? Okay, so that's an issue for the magistrate. So all matters, there's a whole bunch of sentencing considerations that a magistrate will have to take into consideration when imposing a sentence. So completely different to the issue of bails and AVOs, but the answer to your question depends entirely on the seriousness of the assault. What were the circumstances of it? Did they have something else on their record? Was it a first-time offender? What were their, subjective circumstances of the offender? So, bit of a difficult question to answer in terms of straight out why didn't they go to jail, but the magistrate obviously formed the view that there were alternatives to imprisonment as a sentencing option. And then in terms of can the police tell the court not to send someone to custody, police aren't allowed to comment on the ultimate penalty that the court imposes, but in any court proceedings, there is a police prosecutor who's there representing the police, and they do comment on the seriousness of the offences and form a view. So whilst they don't specifically say to the court, don't send them to jail, they do get to comment on the appropriateness of penalties. All right, does anyone else have any other questions or anything we can help explain?
Doesn't seem like there's any more coming in, but that was super, super informative. And I really just want to thank you again for sharing your knowledge and expertise with us. There will be an evaluation link that is sent after the webinar as well. So we really, really appreciate your feedback on this webinar today so we can keep making sure that we're doing it and that they are relevant. And you can also add additional topics that you do want. And again, we're getting a lot of good reacts from people. If you do have any other questions, just put them in the Q&A. And we will try and get to them. But as we said, the recording will be up and we will send around the slides and also some relevant links that we also mentioned in the webinar. We can't give certificates out, but if you do need confirmation that you have attended, you can use the confirmation email that you get from Zoom after the webinar saying that you attended. But if you need any other proof, do get in touch with the email in Zoom, the CLE email. We won't be able to give a certificate, but the confirmation should be enough. But thank you very much for joining, and thanks, Natasha, so much again.
Thank you.
And again, if you do have any more questions that you need answered, feel free to email our team. It's the CLE contact email in the Zoom email. And you can also get in touch with LawAccess. So that's our team at LawAccess. And the number has been put in there as well. I'm not sure, Natasha, there's been a last minute question that has come in, if that's relevant, or we can also email after. Any other advice that involves for particular situations? We do recommend getting starting that first step with LawAccess, and they'll be able to point you in the right direction.
Yep.
Great. Thank you so much, everyone. Enjoy the rest of your day.
Thank you. Enjoy your day.